We are excited to have with us today Robert Glicksman. He is the J.B. and Maurice C. Shapiro Professor of Environmental Law at George Washington University Law School. He's a nationally and internationally recognized expert on environmental, natural resources, and administrative law issues. And he's written numerous book chapters and articles on environmental law, natural resources law, administrative law topics, and regulatory authority and federalism issues in environmental law. What I've asked him to come to talk about today is the regulatory system. If you are in Washington and you cover a department or agency, you're familiar with the regulatory system. If you don't, it's probably somewhat of a mystery to you. I think everybody's familiar with the congressional, what goes on in Congress. What I hope you see is once things leave Congress and go to the departments and agencies, there's this whole other system in which they're interpreting what Congress is asking, just told them to do. And there are great stories and great resources and sources buried within the regulatory system and the public comment process. And it's a great way to localize stories. It's a great way to find stories. It's a great way to find resources and sources. I wanted Professor Glicksman to come give you an overview of how the system is structured and kind of what the points are that you look into it to find those sources and stories. So since we started late, we'll go a little bit late. It's 1:10 right now, and we'll go a little past 2 to get his presentation and questions in. And I'll turn it over to you, Professor Glicksman.
Thank you very much, Chris, and it's my pleasure to be here today to talk to you. I'm going to share my screen with you. I'm going to be talking to you today about administrative law, which is a subject that used to rarely attract public attention. Today, administrative law is ubiquitous and controversial, and it provides a goldmine of material for investigative journalists. Let me try and explain why. Administrative law questions go to the very heart of how our democratic system of government works or doesn't work. Ideas about how the system should work are perhaps more contestable than they've been since the 1930s or 40s. Recent debates echo those that occurred in response to the expansion of the administrative state during the New Deal. New Deal opponents characterized the expanded administrative state as a headless fourth branch of government, which operated outside the Constitution's system of checks and balances and escaped democratic accountability. The Supreme Court in the 1930s reconciled administrative governance with constitutional norms, endorsing the legality of the administrative state. But a recent popular narrative driven by politicians opposed to regulation has been that agencies are once again out of control and have hijacked governance mechanisms. Significantly, several Supreme Court justices have fed this narrative. According to one prominent administrative law scholar, the anti-administrative voices on the Supreme Court are increasingly prominent. Justice Kavanaugh, for example, has complained that administrative agencies are democratically unaccountable, neither elected by the people nor supervised in their day-to-day activities by the elected president. According to Justice Thomas, the existence of independent agencies creates a serious, ongoing threat to our government's design. Leaving these unconstitutional agencies in place subverts political accountability and threatens individual liberty. I think it's impossible to assess these developments without understanding how the administrative process actually works. Unfortunately, that understanding seems to be at a low ebb. High school students regularly score poorly when tested on their understanding of governance mechanisms, and it gets much higher than that. Alabama Senator Tommy Tuberville recently misidentified the 3 branches of the federal government as, quote, the House, the Senate, and the executive. It's also important to understand governance mechanisms because of the policy reversals that regularly accompany changes in presidential administration. Some changes are legitimate efforts to mirror the values of those who voted for a new president, but others are unlawful end runs around the legal constraints that are meant to ensure that agencies operate within the bounds of the law. So here's how I'm going to proceed today. I'm going to talk first about the sources of regulatory authority that agencies exercise. Second, the different forms of administrative regulation. Third, how the regulatory process works. Fourth, and perhaps most importantly, what forms of oversight of agency activities exist and how they work. I will focus on agency adoption and judicial review of regulations because those actions tend to draw the most attention and are often most consequential. So let's start with sources of agency regulatory authority. It's fundamentally important to understand that federal administrative agencies have no inherent authority to do anything. All of their authorities derive from statutes enacted by Congress and signed by the President. Article 1 of the Constitution, which vests all legislative power in Congress, gives Congress the power to formulate national policy by adopting statutes. But because the federal government is a government of limited powers, Congress can only adopt statutes on topics explicitly mentioned in Article 1. And I've got a list of those on the slide, at least some of them. For purposes of administrative law, the most important proper subjects of congressional statutes include regulation of interstate or foreign commerce, control of immigration, taxing and spending, and management of federally owned lands and resources. Article 2 of the Constitution vests the executive power in the President, including the duty to take care that the laws are faithfully executed. The executive branch is therefore responsible for implementing statutes passed by Congress. Now, the Constitution doesn't say much about who comprises the executive branch other than the President and the Vice President, but it does vest in the President the power to appoint officers of the United States with the advice and consent of the Senate. And that's the source of the President's authority to appoint cabinet members and other officials. These officials work for administrative agencies housed within the executive branch. Using its Article 1 powers, Congress has established scores of federal administrative agencies, some of which are noted on the slide. Statutes that create agencies and delegate implementation authority to them are called organic statutes. They create, but they also limit agency regulatory authority. Congress doesn't have the time or expertise to legislate in detail on all the matters within its jurisdiction. So it has delegated to agencies the authority to flesh out statutory mandates. Many of those delegations are quite vague. The Clean Air Act, for example, authorizes the Environmental Protection Agency to adopt air pollution controls that are, quote, requisite to protect the public health. Other statutes allow agencies to adopt regulations, quote, in the public interest, convenience, and necessity. Beginning early in the 20th century, the Supreme Court enunciated something called the Nondelegation Doctrine. It declared that Congress cannot delegate away its core legislative policymaking function. To ensure that it doesn't do that, any delegation of authority to an agency has to contain what's called an intelligible principle to guide the exercise of the agency's policy implementation authority. The Supreme Court has invalidated statutes as violations of the non-delegation doctrine only twice in its history. Both of those occurred in 1935. Since then, the court has accepted very broad and general delegations of authority to adopt regulations that govern private conduct, like the ones I mentioned a minute ago. Recently, though, several members of the Supreme Court have criticized the court's non-delegation doctrine decisions. Justices Thomas, Gorsuch, and Kavanaugh, in particular, have urged the court to take the intelligible principle more seriously. If the court follows their lead and requires greater specificity in legislative delegations, it could significantly hamstring agencies, precisely because Congress typically lacks the time and expertise to legislate in detail. So far, the court has not altered the doctrine that has stood since 1935. But litigants, sensing an eagerness by some justices to curtail agency regulatory authority, have filed suits challenging the constitutionality of various federal statutes under the non-delegation doctrine. But let's shift to a discussion of the forms of administrative regulation. When Congress delegates the authority to an agency, it specifies not only what the agency can do, but how it can do it. There are two main forms of agency action: rulemaking and adjudication. The Federal Administrative Procedure Act, which I'll talk about more in a minute, defines those terms for most purposes. It defines rulemaking as the process for issuing a rule. It defines a rule, in part, as an agency's statement of future effect designed to implement, interpret, or prescribe law or policy. So we might think of rulemaking as a process for adopting, usually, a general, across-the-board policy that regulates conduct prospectively. It's analogous to the adoption of a statute, except that the adopting body is an administrative agency, not a legislative body. What about adjudication? Rulemaking and adjudication are mutually exclusive. The APA defines adjudication as the process for issuing an order, and it defines an order as the end result of a matter other than rulemaking. We might think of adjudication as the process for making an individualized decision involving determinations of the legal consequences of past events. It's really analogous to trial-type decision-making, except that it's conducted by an agency, not a court. The distinction between rulemaking and adjudication is illuminated by a pair of cases decided by the Supreme Court early in the 20th century called Londoner and Bimetallic. In Londoner, a local agency assessed taxes on landowners who would benefit from a local street paving project. In Bimetallic, a state agency decided to impose an across-the-board increase in property tax valuations. The issue in both cases was the failure to convene an adjudicatory hearing before making those decisions, and whether that failure violated the due process clause of the 14th Amendment. The Supreme Court held that the landowners in Londoner, but not in Bimetallic, were entitled to an adjudicatory hearing. The assessment in Londoner was the product of an adjudication. It affected few people in different ways on individualized grounds. The tax increase in Bimetallic was the product of a rulemaking. It affected many people in the same way based on a policy determination. Those characteristics continue to guide courts in distinguishing between rulemaking and adjudication when the APA's definitions don't provide a clear answer. So what must agencies do when they're engaged in rulemaking or adjudication? Agencies have to follow certain procedural steps whenever they adopt rules or adjudicate cases. And those requirements stem from several sources. The most important is the Federal Administrative Procedure Act, adopted by Congress in 1946. It establishes what we might think of as default rules that apply unless displaced by another source of law. And the APA applies to all agencies, with limited exceptions like military agencies. The second source of procedural requirements are agency organic statutes. Remember, these are the statutes that create agencies and/or delegate substantive authority to them. Organic statutes can exempt agencies from APA procedures, but more often they displace the APA in whole or in part by imposing more rigorous procedures. Third, there are cross-cutting procedural statutes. These are statutes that, like the APA, but unlike organic statutes, apply to all or most agencies. They tend to impose additional procedures for agency rulemaking. For example, the Unfunded Mandates Act requires agencies to investigate the costs and benefits of imposing on state or local governments obligations that require monetary expenditures. And finally, we have the US Constitution, and in particular, the Due Process Clause of the Fifth Amendment. In rare instances, statutory procedures are insufficient to meet constitutional requirements. Those instances almost always involve adjudication, not rulemaking. And so in the Londoner case, for example, the Supreme Court ruled that the local tax assessment procedure didn't satisfy the requirements of the Due Process Clause of the 14th Amendment. So what does due process require? Three things: notice to those affected by government action, an opportunity to be heard before being affected by such an action, and a decision by a neutral, unbiased decision maker. In Londoner, the local government, the court said, should have held an adjudicatory hearing to allow property owners to introduce evidence relevant to their individual property valuations. The Fifth Amendment's Due Process Clause imposes similar requirements on the federal government. Federal agency adjudications rarely violate due process because the APA's procedures for adjudication typically meet due process requirements. So what does the APA say about how agencies make rules or adjudicate cases? The APA has separate provisions for rulemaking and adjudication. For both kinds of action, it distinguishes between formal and informal decision making. Start with rulemaking. Formal rulemaking is basically obsolete. Where it is still required, the procedures for formal rulemaking are basically the same as those for formal adjudication, which I'll talk about in a minute. It's a trial type procedure. But Congress has decided that trial type procedures are really not a good fit for the kinds of policymaking determinations that characterize most rulemakings. Now, recently, some Republican members of Congress have introduced legislation that would require most agency rulemaking to follow formal procedures, trial type procedures. Opponents of those bills have claimed that they're designed to make it more difficult to adopt regulations because formal procedures tend to be more time consuming and expensive than informal procedures. To date, the bills have gotten nowhere. Most federal agency rulemaking is informal rulemaking, also known as notice and comment rulemaking. That kind of rulemaking involves three steps. First, the agency must publish a notice of proposed rulemaking in the Federal Register, which is published every day. That notice must describe the reasons the agency is proposing to regulate, neither the terms or the substance of the proposal. The notice also must solicit comments from interested persons, often on a list of specific questions on which the agency wants public input. Second, the agency must consider comments submitted in response to the notice of proposed rulemaking. In recent years, the public comment process has shifted to an electronic process. The federal government has established a web page for the submission of rulemaking comments, and it's an interactive web page. It's called regulations.gov, and there's the URL. It provides a searchable platform for submission of public comments, and you can search by agency or by date, among other things. The third step of the rulemaking process is actually issuance of the final rule, which is also published in the Federal Register, as well as posted typically on the agency's website. The agency must accompany the final rule with what's called a statement of basis and purpose, which in some instances can run into the hundreds of pages. The statement of basis and purpose includes the text of the final rule, and in a section called the preamble, an explanation of the contents of the final rule. Courts have interpreted the APA as requiring responses to significant public comments. And so the statement of basis and purpose will explain whether the final rule differs from the proposed rule, and if so, how and why. Depending on the nature and controversiality of a rule, agencies may receive thousands and thousands of comments on a single rule. Many of them are form comments solicited by regulated businesses or interest groups. When I was in practice many years ago, I was told to go down to the Bureau of Alcohol and Tobacco and Firearms, part of the Treasury Department, to check out the comments on a recently issued BATF proposed rule. It had something to do with record keeping and reporting on firearms. I don't remember exactly. So I went down and I asked the person in charge to show me the comments. And he pulled out a huge mailbag, one of those mail bags you see, gigantic thing. Said, here you go. And I said, really? There are this many comments? He said, no, this is the overflow bag. And then he took me to a room that was stacked full of probably 20, 30, 40 bags of equal size filled with comments on this proposed rule. Well, I did a random sample, and I would say 95% were identical to each other. They were form comments that I assume the NRA or some other interest group had sent out to its members and asked them to solicit, to send in comments. Agencies tend to give no credence to those mass-generated comments. They only respond to comments that genuinely engage with the substance of the regulation. And they have to do that because failure to respond in good faith to significant comments can lead to judicial invalidation of the rule. Now, some rules are exempt from notice and comment rulemaking procedures. Administrative law distinguishes between what are called legislative and non-legislative rules. Legislative rules operate like statutes. They impose binding standards of conduct. Non-legislative rules, for the most part, are not binding. And there are three kinds of non-legislative rules. First, rules of agency organization, practice, and procedure. These are exempt from notice and comment procedures because Congress decided that agencies should have broad discretion to organize and conduct themselves the way they want to. The public has less invested in the way agencies organize themselves than in the substance of the rules they adopt. Second, interpretive rules. An interpretive rule advises the public of the agency's interpretation of a statute it administers or a legislative rule it's previously adopted. Interpretive rules are not themselves binding, but if such a rule reflects a valid interpretation of a statute or a legislative regulation, that statute or legislative regulation is binding. So how do we distinguish between a legislative rule and an interpretive rule? If a rule imposes a new duty on existing parties or creates new rights, it's a legislative rule subject to notice and comment procedures, not an interpretive rule. Third, policy statements, which advise the public of the manner in which an agency proposes to exercise one of its discretionary powers in the future. It announces the agency's intention to adopt a new duty or enforce an existing duty in some future adjudication or rulemaking. Neither interpretive rules nor policy statements directly and immediately affects people the way legislative rules do, which reduces the need for solicitation of public comments. Together, interpretive rules and policy statements are known as guidance documents. The Trump administration imposed new procedural requirements on guidance documents, viewing them as an underhanded way to adopt rules without public input. But regulated entities, businesses, often ask agencies to issue guidance documents, which can assist them in understanding and complying with the regulatory obligations. For that reason, among others, the Biden administration has repealed the extra Trump procedures for guidance documents. A second category of rules that need not comply with notice and comment procedures are rules covered by the APA's good cause exception. Agencies need not comply with notice and comment procedures if they have good cause to adopt regulations quickly and can explain why notice and comment procedures would be unnecessary, impractical, or contrary to the public interest. This exemption tends to be limited to emergencies or situations when giving notice to the public of a proposal would allow affected interest to anticipate the final regulation by engaging in the very conduct the regulation seeks to prohibit before the regulation goes into effect. All right, what about adjudication? Again, there are two forms, formal and informal. Formal adjudications are trial-type proceedings. They're usually adversarial in nature, with opposing parties contesting the issues like at a judicial trial. They're presided over by administrative law judges, whose method of appointment and removal shields them, at least to some extent, from control by the agencies they work for. Parties to a formal adjudication can call witnesses and cross-examine witnesses called by other parties. And the administrative law judge's decision has to be based entirely on evidence adduced at the hearing. If the APA's provisions for formal adjudication don't apply, then the applicable procedures are dictated by the agency's organic statute, its own regulations, or rarely the due process clause. As a result, the procedures for informal adjudication vary widely. In general, if there is a trial, it's conducted by a hearing officer who's less independent from the agency that employs the officer, even if the agency is itself a party. Opportunities to call or cross-examine witnesses are limited, and the evidence that the agency can rely on in making its decision extends beyond that introduced in trial-type procedures. So, agencies have fairly broad authority to engage in adjudicatory or rulemaking actions. But what about those concerns about the lack of accountability? Those are dealt with through the imposition of various forms of oversight on agency activity. And I want to talk about three different forms of oversight. But first, I want to make a general point. Congress, for reasons I talked about, often vests broad discretion in agencies to take advantage of their expertise and experience. But Congress is not willing to provide agencies with unlimited autonomy. And the non-delegation doctrine, at least in theory, doesn't allow them to do that. And so there's a recognized need for oversight of agency officials who are not elected and therefore lack direct democratic accountability. Oversight is provided by Congress, by the president and his subordinates in the executive branch, and by the federal courts. A key task of administrative law is to balance the desire to afford autonomy to agencies so they can use their expertise while ensuring that they're accountable. So what forms of congressional oversight are there? Well, there are many, and I'm sure you're familiar with all of them. Congress conducts oversight hearings at which its members grill agency officials like Dr. Fauci. It can amend agency organic statutes to narrow agency discretion if it doesn't like what agencies have done, or it can actually reverse agency decisions. It can use appropriations legislation to control agency expenditures, and even to make substantive changes to agency authority through appropriations riders. And we're seeing that now in the form of proposed legislation to exempt some infrastructure projects from the environmental statutes to make them move more quickly. The 1996 Congressional Review Act allows Congress to use a fast-track process to adopt legislation that rescinds a recently adopted agency regulation. And once rescinded, the agency may never adopt a similar regulation in the future unless Congress passes another statute allowing it to do that. Before 2017, Congress resorted to the Congressional Review Act only once, the beginning of the George W. Bush administration. But once Trump took office, Congress rescinded 17 Obama regulations. Congress is expected next week to rescind a Trump regulation that itself rescinded an Obama regulation requiring oil and gas operations to control methane leaks. Senate's already passed the bill. It's scheduled to be voted on by the House on June 22nd, so look out for that. What about executive oversight? Well, the president can control agency policymaking in many ways. For example, by appointing agency officials who agree with the president's policy preferences. High-level officials require Senate approval. Congress can delegate the power to appoint lower-level officials to the president, to agency heads, or to the courts without further congressional involvement. The president can also control agencies by firing or threatening to fire agency officials whose actions he disapproves. Think about Jeff Sessions. The scope of presidential removal power differs for executive and independent agencies. So what's the difference? Executive agencies are usually headed by a single official who's removable at will by the president. Most cabinet officials, the head of the IRS, the head of EPA. Independent agencies are usually multi-member bodies like the SEC or the NLRB, whose members by statute may only be removed for cause. The meaning of good cause is not settled, but typically it includes malfeasance or failure to faithfully execute the laws. Congress creates independent agencies to shield them to some extent from presidential supervision. It wants to control the reins of oversight. Recently, some scholars have argued that independent agencies are unconstitutional. Under the unitary executive theory, they say, good cause removal provisions are improper congressional intrusions on the president's unilateral authority to control the executive branch. Some Supreme Court justices have expressed sympathy for that argument. The court has not yet invalidated independent agencies, but efforts to convince it to do so will certainly continue. And finally, the president can engage in direct oversight over agencies by issuing executive orders. These have no effect on non-governmental entities, but they're binding on agency officials, although they can't direct agencies to violate statutes. Some of the most significant executive orders issued in the last 40 years have required agencies to engage in what's called regulatory impact analysis, like cost-benefit analysis, before issuing regulations. Executive orders issued by presidents dating back to Reagan require agencies that want to adopt regulations with a significant economic impact to submit a cost-benefit analysis to an agency called the Office of Information and Regulatory Affairs, OIRA, which is within the Office of Management and Budget. The agency can't issue a regulation until OIRA has cleared the regulation by approving the cost-benefit analysis. Critics claim that OIRA's aims are not always consistent with the organic statutes under which agencies seek to regulate, and that OIRA in particular prioritizes economic efficiency values, even when the relevant organic statute doesn't. Others claim that the OIRA review process lacks transparency and that OIRA provides preferential backdoor access to regulated entities, but not to regulatory beneficiaries. Finally, what about oversight by the courts? Many organic statutes allow litigants to challenge agency actions in court. Even if an organic statute doesn't do so, judicial review is almost always available under the APA. And either the APA or the organic statute will dictate whether the suit needs to be filed in federal district court or in one of the courts of appeals. The rigor with which courts review agency determinations depends on the nature of the issue being reviewed. The so-called standard of review differs for factual questions, legal questions, and policy determinations. Courts apply either the substantial evidence or arbitrary and capricious test to review of agency factual determinations, depending upon the nature of the proceeding. If it's formal, the standard is substantial evidence. If it's informal, it's arbitrary and capricious. In theory, substantial evidence review is more rigorous, more searching, but they're both pretty differential when it comes to factual questions. The proper standard of review for questions of law is a lot more controversial. In 1984, the Supreme Court decided the Chevron case, highlighted on the slide. In that case, the Supreme Court announced a two-step test for review of an agency's interpretation of its own organic statute. Under step one, if the statute's clear on the precise question before the court, the reviewing court simply applies the statutory meaning without regard to how the agency interprets it. But if the statute's ambiguous, the reviewing court must defer to any reasonable agency interpretation. Well, what's the rationale for judicial deference to agency interpretations of ambiguous statutes? That seems like something a court ought to be able to do on its own. In Chevron, the court said there are three reasons. Number one, the agency is likely to better understand the effects of competing interpretations of a statute because it works with the statute on a daily basis. Number two, if the statute is unclear, it means that Congress implicitly delegated to the agency the authority to resolve statutory ambiguities, and the courts need to respect that delegation. And third, agency officials have criticized, agency officials are relatively more democratically accountable than federal judges who have lifetime appointments. Now, some scholars and judges have criticized Chevron deference, calling it an abdication by the courts of the judicial power. They've argued that Chevron is inconsistent, for example, with the arcane Supreme Court decision in Marbury versus Madison, which says it's the duty of the courts to say what the law is. Chevron's defenders disagree, arguing, for example, that courts fulfill their responsibilities by independently applying step 1 or deciding whether an agency interpretation is reasonable at step 2. Some Supreme Court justices are antagonistic to Chevron. The court hasn't yet repudiated Chevron and probably won't do so anytime soon, but it's narrowed Chevron's scope. Chevron no longer applies to agency interpretations found in non-legislative rules. It no longer applies to questions of major economic and social significance, which the court said in the second Affordable Care Act case, King versus Burwell. I expect the Supreme Court to continue to chip away the scope of Chevron's applicability. Furthermore, if the Republicans regain the presidency of both houses of Congress, they will certainly seek to overturn Chevron by statute, as they've tried to do thus far without success. Finally, what about mixed questions of law, fact, and policy? How do courts review those? Under the APA, the applicable standard review is the arbitrary and capricious test, which is supposed to be very deferential. In a case called Overton Park, the Supreme Court said that a decision is arbitrary and capricious if it reflects a clear error of judgment or is not based on relevant factors on the organic statute. In 1983, in State Farm, the court elaborated. It said, there are 4 circumstances in which an agency policy determination needs to be reversed. First, if the agency relied on improper factors. Second, if it failed to consider an important aspect of the problem. Third, if its explanation runs counter to the evidence. Or fourth, if its explanation is implausible. In 2 contexts, which I think you'll run across if you pay attention, courts applying arbitrary and capricious review are likely to take a very close look at an agency's explanation. The first involves an agency flip-flop on a policy matter, which of course happens with increasing frequency as presidential administrations shift between political parties with diametrically opposed agendas. Now, agencies have the right to make changes in policy to reflect election results. But if the facts underlying the 2 sets of decisions remain the same, a court will insist that the agency acknowledge that it's making a change and explain why policy reversal is appropriate, notwithstanding the absence of factual change. The federal courts invalidated literally scores of Trump agency decisions for failure to provide that kind of explanation. The other context in which rigorous review is likely to occur is when the agency's explanation for its decision doesn't ring true. An example is the Trump administration's decision to add a question to the census about citizenship status. In the Department of Commerce case, the court reviewed Secretary of Commerce Wilbur Ross's justification for that new question, which he explained as an attempt to achieve better enforcement of the Voting Rights Act. The Supreme Court found the explanation to be pretextual. It was essentially made up by Secretary Ross after the fact to cover up the real reason for the decision. Chief Justice Roberts, who wrote the opinion, said, the evidence tells a story that does not match the Secretary's explanation. The sole stated reason seems to have been contrived, and therefore the court reversed the decision and sent it back to the agency. There is, of course, one final source of oversight, and I'll end with this, and that's the 4th estate. That's the press. The press, especially investigative reporting, can provide an important check on agency activities. And a great example is the recent press stories about the Trump Department of Justice investigations of the phone calls and emails of Democratic members of the House Intelligence Committee, Representative Schiff and Swalwell. So the press can pick up things that Congress, the courts, and the executive branch doesn't. And remember that the Freedom of Information Act is a tool that may provide access to reporters to information that the agency would otherwise be able to shield from public scrutiny. So I'll stop there and field questions on anything I said or neglected to say.
Jumps. Rachel, up first.
Hi, yeah, Rachel Riley with the Everett Daily Herald. I wanted to see if you have any advice for how we can track ways in which lobbyists lobby agencies as opposed to legislators. I was looking recently at some of the reports that my state has available, and they seem to have a lot of specifics about lobbyists lobbying lawmakers, and it's a lot more vague when it comes to what lobbyists are doing to influence administrative agencies.
Yeah, I have a couple of ideas. First, you could go to regulations.gov and see what comments are being submitted and by whom they're being submitted. Those comments are publicly accessible. That's out-front lobbying. There's no attempt to hide that. But you can at least get a sense for who's invested in a particular proposed rule and how it's urging the agency to change what it's originally intending to do. Second thing may be more difficult, but OIRA is supposed to make available to the public logs of its meeting with interested persons. It hasn't always done that, but the Biden administration is committed to transparency, and I would hope that it will do a better job of making those logs of meetings with members of the public and interest groups available more than the Trump administration has done. And again, the point there is they're trying to get OIRA to block an agency regulation they don't like. And so I think both of those are good ways to keep track of what lobbying is taking place. A third way is to look at the trade press in particular areas. So I teach various environmental law courses, and I subscribe to Bloomberg News and various other publications, the E&E Reporter series. And every day there are stories about what agencies are thinking about doing and who's trying to stop them or press them to do that. So those are three ideas that I think could bear fruit for you.
Thank you.
You had mentioned that the agencies don't give any credence to the mass numbers of replicative comments. Does it? I mean, if there are tens of thousands of comments coming in on a particular proposed reg, does the sheer number ever kind of sway them, even if they all say the same thing?
It might, in the sense that if there's a massive input of comments, the agency might actually decide to hold hearings, public hearings, to solicit public input, or it might decide to extend the comment period. Usually they provide a 6-day comment period, but if they're getting flooded with comments, they might decide, well, we need more time to let people weigh in and for us to consider these comments. So those would be the two ways that I think it would most directly affect what the agencies are doing. I don't think they're going to say, well, because we got 1,000 identical comments instead of one, this is a more important issue and we're going to pay more attention to it. That just means that the interest group that was invested cranked up its machinery and got people to sign off on forum comments.
Mm-hmm. Okay. And do you think, so YAML has a comment. I've also found at times the websites freeze up that include comments on regulations. It just, oh, okay, yeah. So things, if they are getting swamped, they might freeze up. I mean, is there a way to, for either for reporters or for agencies to, I guess, try to wade through the mass numbers of comments? Or, I mean, the regulations.gov has a good search function, so you can look for key terms. But is there a way to look and kind of exclude all the repetitive stuff and focus on the unique ones?
I'm not aware of any way to do that. I guess you just gotta have to use trial and error and use different search terms. And I would think that the form comments are probably going to be fairly simplistic in the terminology they use. And maybe if you look at the language of the proposed regulation, the text of the regulation, pick out a couple of fairly sophisticated terms of art and use those as search terms, you're probably going to exclude most of the form comments and get to the ones that go to the meat of the proposal.
And do you get this is a fairly vague question here, but do you get a sense that, when it comes to public comments, does the good stuff actually make it into the submitted public comments? I mean, the good stuff meaning the good analysis from outside interest from the lobbying groups. Do they end up putting their comments in public through the public comment process, or do they mostly try to stay in the shadows?
They definitely put them in the public comment process for a very important reason. If the agency solicits public comment on a proposed regulation, and somebody, let's say an environmental NGO, doesn't submit comments, the agency issues the final regulation. The NGO says, this isn't good regulation, we're going to challenge it in court. The court might throw them out on the ground that they had an opportunity to make their point before the agency and failed to do so. That's a doctrine called exhaustion of administrative remedies. And it provides a basis for a court to toss out a case without ever reaching the merits. The idea here is, if you have a problem with the regulation, let the agency know so they can respond. Maybe it will agree with you and will issue the regulation you want, but at least it has an opportunity to weigh in so that if the agency disagrees with you and you challenge the regulation in court, the court will have not only your criticism, but the agency's evaluation of it in reviewing the validity of the final regulation. So failure to submit comments risks not being able to challenge a regulation or other action in court.
Okay, so we have time for another question or two. I have one dealing with the Chevron defense. So Chevron was decided in 1984 under a fairly liberal court. Now the court is much more conservative, and you said they've been chipping away at it. Is the Chevron defense generally seen as the liberal view, and conservatives are chipping away at it over the last 3 decades?
I would say that's overly simplistic in the sense, and this probably won't surprise people, but when there's a Democratic administration, progressives tend to like Chevron because the courts are reviewing agency determinations that tend to be ones they like. When there's a Republican administration, progressives don't like Chevron, they don't want deference, and precisely the reverse is true of conservative scholars and other individuals. For reasons I don't completely understand, but I guess I have a guess. In recent years, it's been the conservatives that are more exercised over Chevron than the progressives have. And it'll be interesting to see whether conservative judges apply or don't apply Chevron, defer or don't defer under Chevron to Biden administration agency determinations. But I think that the attack on Chevron is part of a broader attack on the administrative state as being out of control and imposing unwarranted burdens on the private market. And so if you can weaken agencies in any way whatsoever, that's a good thing from the perspective of opponents of big government.
And final question from me, and if anybody else has a question, raise your hands. You do environmental law. Are there any kind of trends as to what kind of regulations and guidances kind of animate the public the most and yield a lot of comments? Is environmental law particularly? I mean, is there a lot of public comment that comes in on environmental law? You had also mentioned a gun ownership case. What are the topics that kind of use the public comment process the most?
I just think the hot button issues that we read about in the press every day tend to be the ones that generate the most activity, the most comments. So environmental regulation, which really provokes very different policies on the part of Republican and Democratic politicians and administrations. Immigration would be another one. Gun regulation, healthcare, Affordable Care Act. Certainly, Affordable Care regulations generate a lot of commentary. So any hot button issue on which there seems to be a pronounced divide between the two political parties is likely to generate a lot of public comment and controversy.
Okay.
Labor relations would be another one.
All right, and this might be the final question from Rachel.
Just curious what your thoughts are on, Biden's EPA so far, and whether or not, you think we'll actually see reversals of some of the rollbacks that were done by the Trump administration.
Well, we already have seen reversals of some regulations. The so-called secret science rule that the Trump administration uses is already gone. And it seems pretty clear to me that the EPA under Biden will reverse a significant number of Trump agency deregulatory actions. The most important one is perhaps the one that deals with climate change regulation of electric utilities, fossil fuel-fired electric utilities. The Obama administration issued the Clean Power Plan, which was repealed by the Trump administration's Affordable Clean Energy Rule. In one of his early executive orders, Biden ordered EPA to review and make necessary revisions, if appropriate, in the Affordable Clean Energy Rule. That will happen. It's not yet clear what form it will take. My guess is it will not go as far as the Obama Clean Power Plan did in terms of its reach, because there was judicial skepticism of that, even though the Supreme Court never authoritatively ruled in. But you will see a broader rule than the Affordable Clean Energy Rule. You're certainly going to see reversals of the Trump administration's rollback of the CAFE fuel efficiency standards issued by EPA and the Department of Transportation. So those are just some examples. Another thing to watch is the so-called Waters of the United States rule under the Clean Water Act, where the Trump administration significantly narrowed the streams and other small bodies of water that are covered by the Clean Water Act's protections. That's going to be changed by the Biden administration.
Okay, and with that, I think we need to draw this session to a close. Professor Glicksman, I want to thank you very much for coming to share your insights, and you have a great, very detailed PowerPoint that'll be a good resource for fellows trying to continue to study the regulatory process. So thanks you again also for being flexible on the timing of this.